Good morning, everyone. Welcome to our Cybersecurity Festival, our very first one from Stanford University. It is my pleasure today to introduce Riana Pfefferkorn. She's the Associate Director of Surveillance and Cybersecurity from the Center for Internet and Society at Stanford Law School. And today she's going to talk about compelled device decryption and the Fifth Amendment.
All right, thank you everybody for coming. We're happy to be part of the first ever Cyber Fest. And thanks for the introduction. I work over at the law school and I want to do some disclaimers before I dive in. I am a lawyer, but I am not your lawyer. Nothing I'm going to say here is legal advice or illegal advice, and these are just my opinions and not those of Stanford or the law school or Center for Internet and Society.
Position itself
Over here?
Block a little bit. Yeah, block the words.
Oh, sure. You guys see what my slides say?
Yeah.
Okay, cool. A few words on scope. This talk is not going to be about searches at the United States border. The law around border searches of people's devices and compelling them to do stuff with your devices at the border is a whole other can of worms. So what I'm going to be talking about is just going to be confined to compelled decryption in the context of law enforcement within the U.S. border, not at an airport, not at a land crossing, not a seaport of entry. This talk is also not about the Fourth Amendment. The Fourth and Fifth Amendments to the Constitution protect different, although overlapping, rights. The Fourth Amendment protects your right to privacy. We're not going to talk about that here. The Fourth Amendment sets forth the conditions under which the government can ask for warrants, and it protects you against unreasonable government searches and seizures. But we're going to assume for our purposes that there's already a warrant for the device, because you cannot be compelled to decrypt your device unless there is an underlying warrant, some other form of court order that's meant to give effect to a warrant. Law enforcement can ask you nicely to unlock your device voluntarily, but they cannot compel you to open it. So we're going to assume that there has been a valid warrant issued for a device, although there is also the possibility under the Fourth Amendment that warrants for searches and seizures of devices have some sort of instability and don't comport with the Fourth Amendment, but that's not our concern today. If you are curious about these topics, about the Fourth Amendment issues, or about border searches, I'm going to have a slide up at the end that has some suggested reading and resources. And you can also always just contact me afterwards and I can put you in touch with some resources you can check out. So this talk is about the Fifth Amendment. Here's the text of the Fifth Amendment. The Fifth Amendment protects a number of your constitutional rights, actually. It includes the grand jury clause, it includes the double jeopardy clause, it includes the taking clause, it includes the due process clause. But the one that we're going to be talking about today is the self-incrimination clause. No person shall be compelled in any criminal case to be a witness against himself. It sounds pretty simple, but it's actually kind of not. There's a really complicated body of Fifth Amendment law. I'm only going to be giving you the very condensed version for half an hour at most today. So it is a big hairy area of law. We're going to focus just on the encryption part of it. So you might be asking yourself, well, what does the Fifth Amendment have to do with encryption? Well, if a device is encrypted or if files on it are encrypted, that can impede the execution of a warrant to search and seize the device. If encryption does turn out to be a barrier to law enforcement when they try and seize and search a device pursuant to a duly issued warrant, they have a few different options. One of them would be maybe there's cloud backups for the contents of the device, and you can go to Apple with a separate warrant for, say, your iCloud account and get a download of the backups of your phone to your iCloud account. But maybe you don't have backups turned on, or maybe there is a backup, but the most recent one isn't that recent, and it doesn't necessarily include the investigatory time period that law enforcement is interested in. Another option would be to ask Apple for an iPhone or Google for an Android phone to unlock the phone for law enforcement. That hasn't been a good legal option since the famous Apple versus FBI fight in 2016, and it is no longer a good technical option because most of the more recent versions of smartphones, probably the kind that you all have in your pocket by now, do not provide a way, in terms of the encryption design, for Apple or Google to be able to get access to that data themselves, even if they wanted to. Not even the manufacturers of the phone can get into the plain text of encrypted data anymore. So a third option, if those two don't work, is for law enforcement to use a tool for doing forensic analysis of a device that can extract unencrypted data off of the phone by exploiting some existing vulnerability that's in the encryption software. So law enforcement has access to a couple of different tools for being able to do that. Some of the more better known ones are called Celebrite or Gray Key tools. And those are things that are made by third-party vendors, private companies, that the government, various law enforcement agencies, both federal and sometimes at the state or city level, have contracts with those private companies to buy these tools and then use them to extract information from what would otherwise be locked encrypted phones. But those don't always necessarily work consistently. There are a lot of different phone handset models out there. There are a lot of different versions of the software for the mobile operating systems. And Apple and Google are always in a cat and mouse game with these companies to try and figure out what it is that is the flaw in their software that Celebrite and the makers of Gray Key are exploiting to be able to get access, and then they try and close those vulnerabilities, and then the tool doesn't work, and then Celebrite and Gray Key have to go back to the drawing board and try and update it, right? So those don't always necessarily work, although it doesn't prevent the government from spending hundreds of thousands of your tax dollars on buying those tools. So finally, if none of the above had worked to try and get access to an encrypted device, law enforcement can try and force the owner of the device to decrypt it, and that's where the Fifth Amendment comes in. So this is not necessarily a brand new idea. I think it's something that's gained more relevance and more importance in recent years. But the first idea of the possibility that the Fifth Amendment right against self-incrimination might protect you from being compelled to decrypt encrypted files goes at least back to the 1990s when a bunch of libertarian activist hackers were talking about this as a possibility back on BBSs back in the day. At the time, encryption software had only just started being available just to regular consumers like you and me. Prior to that, it had mostly been used by banks, by financial institutions, by the military, by governments. But in the 1990s, we were starting to see the ability to encrypt web connections over browsers, to encrypt your email. And so people were starting to think about this question. But the first court case that weighed in on this issue of whether your right against self-incrimination protects you from being compelled to decrypt a device or files didn't come out until 2007, and that involved files on a laptop that had been encrypted that was seized and searched during a border crossing up in Vermont. This issue has become a lot more relevant now in the intervening dozen years or so because now encryption is prevalent for your devices. It's often configured by default. Everybody's smartphone in here, you probably, hopefully, have a passcode on it that will cause your phone to encrypt itself, or the files they're on to encrypt themselves as soon as you lock it. And there's also multiple means to be able to decrypt your information now. You can use a passcode, a password, or passphrase. I actually use passcodes to refer to all those concepts. You can also use a biometric, such as your fingerprint, or now even your face. And so in recent years, we've seen more court cases come out that have addressed this question, but the law is still evolving, despite the fact that we have seen some general trends in the law. It's still unsettled, it varies by jurisdiction, and the Supreme Court hasn't yet weighed in. So you might be wondering, from these general trends, how can we elucidate a general rule? Does the Fifth Amendment protect you from being compelled to decrypt your encrypted device or your files? A note on the asterisk here around you. I'm going to mostly talk about defendants in this talk, but the Fifth Amendment doesn't just protect defendants. There are other people who might have very good reason to want to invoke their Fifth Amendment rights against being compelled to decrypt their device for law enforcement. That might be the victim of a crime, where the police think that their phone might have some relevant information on it. It might be witnesses to a crime. Everybody can invoke the Fifth Amendment, not just people who are already being prosecuted for something. So I'm going to talk about defendants, I don't mean just defendants. But anyway, going back to the general rule, overall right now, under the state of the court cases to have come out so far, if you use a biometric to decrypt your device, generally you can be compelled to unlock it because the courts say that a biometric is something that you are. It's your fingerprint, it's your face. And if you use a passcode, by contrast, in general, you can't be compelled to unlock your device because a passcode is something that you know, it's the contents of your mind. But there are exceptions to each of these things, as I'll explain. In order to understand the court cases that deal with this issue, there are two key concepts that you need to know about. One is called the active production doctrine, and the other is called the foregone conclusion doctrine. So as a general matter, law enforcement is able to compel people to hand over documents and hand over records. Think of subpoenas, think of warrants. That's how the government collects information for an investigation. The active production doctrine is meant to allow the government to keep doing investigations and gather evidence in its investigations while still protecting your constitutional rights. But the Fifth Amendment only protects you from being incriminated against by your own compelled testimonial communications. And what the active production doctrine recognizes is that an act can be testimonial, not just something you say. Something you do can also be testimonial. The act of producing evidence can itself communicate something. What is that? It means that you're communicating and testifying to the fact that the evidence exists, you're handing files over, that you possess it, that you have control over it, and that you think it is authentic and responsive to the government's demand for particular documents or information. However, not all acts of production are protected by this doctrine. In order to be in order to be protected by the Fifth Amendment, an act has to be compelled. If you voluntarily decrypt your device, if you voluntarily hand over information to law enforcement, then it's not being compelled, and the Fifth Amendment doesn't protect you. It has to be incriminating, which means compliance has to put you at some sort of legal risk. You know, if somebody says, hand me that burrito, and you hand over that burrito, like, unless you poisoned it and you're going to murder somebody with it, like, there's nothing incriminating about handing over the burrito. And finally, it has to be testimonial. And that last one is what's a little bit more difficult to understand. The courts have really grappled with this question. An act is testimonial if it discloses the contents of your mind. But if it gives no indication of your thoughts, of your knowledge, it doesn't tell the government anything, then it's not testimonial. And this has really been kind of a sticking point for the courts. And usually, the courts have gone back to an example that the Supreme Court gave several decades ago, back before smartphones, of what is and what is not a testimonial act. So the court compared two compelled acts. One would be surrendering the key to a strongbox. The court said that's not testimonial. Doesn't involve the contents of your mind at all. Whereas if you were to reveal the combination to a wall safe, that would be testimonial because you're using the contents of your mind. So that's the active production doctrine, but you remember I mentioned that there's also something called the foregone conclusion doctrine. And this is kind of an exception to the exception, which is the active production doctrine. Under the foregone conclusion doctrine, an act of producing evidence is not protected by the Fifth Amendment right against self-incrimination if the information that you are conveying through that act is a foregone conclusion because it doesn't add really anything to what the government already knows. The idea here is you're not telling the government anything that it doesn't have already, and so the act can be compelled. It's a foregone conclusion that they were going to be able to find that stuff out anyway. So as an example, and this again comes from another Supreme Court case, if the IRS is trying to compel you to hand over records that they think will show tax fraud, if they already know that certain business papers exist and that you possess them and you have custody over them, you control them, and that those documents are authentic, then it's a foregone conclusion that they already know those aspects that would be compelled, that would otherwise be conveyed by you handing over that device or that information. You might be wondering to yourself, well, like if it's a foregone conclusion and they already know all this stuff, then why compel somebody anyway? Well, just because the government knows that these tax, relevant documents exist, you might have them in, your briefcase, and that those are real authentic documents. That doesn't actually put them into the IRS's hands. They still need you to take that final step of handing those things over. So how all these doctrines come into play when we apply them to the context of smartphones? Well, for biometrics, we have to go back to sort of the more recent way that people have been allowed to now unlock their phones. As I said earlier, in general, the courts consider biometric not to be testimonial because it's something that you are. It's a face, it's your fingerprint. And it's similar, the courts have said, to the compelled exhibition of bodily characteristics, such as being forced to give a blood sample, being forced to give an exemplar of how your voice sounds, having to put on a hat or a glove, for example. The Supreme Court has said that all of those things do not count as being testimonial. It's just an exhibition of a characteristic of your body. And the courts have said that using a biometric is much more akin to being forced to hand over a strongbox key than to be forced to give a combination to a safe. There is a minority view among a handful of courts, only about 5 to date, that have said, a biometric is testimonial in the same way that a passcode would have been. 2 of those judges have been overturned on appeal so far, and a third one is still pending. But the rationale that those minority courts have used is to say, look, when you're touching your finger to a sensor, it's still a testimonial act because it's testifying to the fact that you have possession or control over the device. And they've said this isn't akin to forcing somebody to give a fingerprint because you could then compare the fingerprint to a print that was lifted from a crime scene. It's much more akin to the physiological responses that are taken when you undergo a polygraph test. The polygraph tests are something that the Supreme Court has said is testimonial. So that's the comparison and the rationale that these minority courts have used. When 2 of those 5 have been overturned after the government appealed that decision, the reviewing court has said, no, this isn't testimonial, because the usual way that these orders work is that it says that the agents are allowed to press each of your fingers in turn onto the Touch ID sensor until they hit upon the finger that opens the phone, or they hold up the phone to your face so that it will unlock. And so in that situation, where it's basically the government doing all the work and pushing your fingers down on the sensor, there's no part of your thought process that's being invoked there at all. The courts have pointed out, you could be unconscious and the government could still put your finger onto the Touch ID sensor. So how could you possibly be using the contents of your mind here? It's not any different than being forced to turn over a key. So in sum, at least until this minority view takes hold and overcomes what other courts have said so far, if you use a biometric to unlock your phone, invocation of your Fifth Amendment rights is not likely to succeed. By contrast, the courts universally have agreed, the ones that have considered this issue so far at all, that a passcode is testimonial because you're using the contents of your mind. It's something that you know mentally. And that might seem pretty open and shut, but for the foregone conclusion doctrine that we talked about. The foregone conclusion doctrine will defeat a Fifth Amendment claim if the government can show that it already knows the information that would be communicated by your compelled act of decrypting the phone with your passcode. But here the courts have not agreed on what is the proper focus of this analysis. Some courts have said that what the government has to show that it knows is that incriminating files exist, what incriminating files there are on your phone that they're trying to get at. Other courts have said that the government only has to show that the defendant knows the passcode. That's a much lower bar, because in general it's going to be fairly easy for the government to be able to show that you know the passcode to your own phone, whereas showing that they already know what files there are on the phone, which is the whole point of why they're trying to get into the phone, that's generally going to be harder. So the government wants to be able to play it both ways, and ideally it wants to have enough evidence that even if it doesn't know which of those tests the court is going to end up applying, the passcode-focused one or the files-focused one, they'll be able to have enough evidence to show it either way. And so some of the things that courts have said have sufficed to establish the foregone conclusion doctrine applied. These are all from real cases. The defendant may have talked to an investigative agent and admitted that the device was his, or may have admitted to the agent that there was illegal stuff that was on the device, or even may have voluntarily decrypted the device in front of the agent when there wasn't a warrant, the agent just asked them to, and then even sometimes have let the agent go through their unlocked laptop or their unlocked phone, and they've seen those incriminating files, but then before they could go and get a warrant to search and seize the device locked itself up and encrypted again. And finally, sometimes you get situations where defendants have either told people about the incriminating illegal files on their device, or they've even shown them to other people, and those people went and told the cops. So the upshot of all this is that it depends whether the Fifth Amendment can protect you from being compelled to decrypt your device. That's the lawyer's favorite answer. It depends. If you use a passcode, there are still better odds that you'll be able to successfully invoke the Fifth Amendment than if you use a biometric. But the foregone conclusion exception still might get you depending on what law enforcement knows. This makes it really hard to predict in advance whether a Fifth Amendment claim is going to succeed or not. Like I said, the law is still evolving. The courts don't all use the same analysis, the same test, and the outcome can be extremely fact-dependent. What the cops already know, that matters. Are they going to be able to establish the foregone conclusion exception? The more that they know, the more likely that they can. The wording of a warrant or court order that authorizes the compulsion, that might matter. Because while I said that usually these orders say that the government is authorized to just push each of your fingers down, but if the way that it is worded is, you order the person to choose which finger it is and put that onto the sensor, well, then you're using the contents of your mind. And then that might still be testimonial, even if a biometric otherwise typically would not be. How the cops execute the warrant matters. The wording of the order to compel you to unlock your device might be constitutionally sound, but if the government executes a warrant unreasonably, that could violate the Fourth Amendment, or if the order says you push every one of the person's fingers down onto the Touch ID sensor, but the cop instead says you pick the finger and you do it, that might be a violation of your Fifth Amendment rights. And then finally, which court the defendant is being prosecuted in, that matters. Only 2 federal courts of appeal, certain courts of appeal, have addressed this question so far. Those are the 3rd and 11th Circuits. The 11th Circuit covers the extreme southeast of the United States. The 3rd Circuit covers Pennsylvania, Delaware, and New Jersey. And only 2 state high courts, state Supreme Courts, have weighed in so far, although we're waiting for 3 others to weigh in on this. And those courts have disagreed among themselves on whether you should use the passcode focus test or the files focus test. The worst state to be prosecuted in, for my money, is Florida. Florida is part of the 11th Circuit, so if you're in federal court, you're going to be covered by one court test. And if you're in state court, well, 2 different circuit courts, like intermediate courts of appeal in Florida, have weighed in, and they used different tests. And one of them even disagreed with itself when it came out in 2 different ways in 2 different cases. So you have no idea, depending on which part of the state, whether you're in state or federal court, and maybe even how the court feels that day versus how it felt the last time it considered this question, how this issue is going to come out. And all of this suggests strongly to me as an attorney that there really needs to be a uniform rule. We're not going to have one until the Supreme Court weighs in on this question, and then what it says goes. The single rule would lend a lot of predictability and consistency. It would tell the courts how to resolve these issues consistently. It would tell the police how they are allowed to go about trying to compel people to unlock their phones. It would tell criminal defendants or people who are asked to unlock or demanded to unlock their phones what they can expect and what their rights are. And also, having one consistent rule would help us avoid the current situation that we're in, where your constitutional rights depend on whether you just happen to use a biometric or a passcode. And that's probably something that you did not pick on the basis of thinking maybe someday I'm going to get arrested and there's going to be a warrant to search my phone. Your threat model was probably something more like, is my kid going to press my finger to my iPad while I'm asleep and run up my credit card charges to buy stuff in game for Pokemon? So what should you do? Again, none of this is legal advice. The common sense thing would be, because the foregone conclusion doctrine and the application of these Fifth Amendment claims is so fact dependent, if you do have illegal stuff on your device, hopefully not your Stanford device, please don't show it to other people, don't tell people about it, please especially don't tell the cops about it. That's how the foregone conclusion exception will get you. Overall, using a passcode is going to be stronger constitutionally than a biometric for now, at least, unless and until courts start to agree that a biometric is also testimonial. If you are in a situation where you usually like using a biometric, but you might be in a situation with increased risk of being arrested or having your phone seized, such as if you go to a political protest, you might want to temporarily switch to passcode. And you might also want to enable a feature that is now available on both iOS and Android devices. It's called the panic button on iPhones, and it's called lockdown mode on Android. If you have that option enabled, then when you invoke it, usually by pressing a button a few times fast, it'll bring up the option to temporarily disable biometrics and require you to enter a passcode or a pattern or whatever. And this has come in handy, actually, in the real world, in the recent Hong Kong protests where the police basically stole a guy off the street and wanted to unlock his phone with his face, but he had this option enabled, so they weren't able to do it. So what do you do if the cops have a warrant and they do demand that you decrypt your phone? Well, the first thing is to lawyer up. If you don't have a lawyer, I can recommend some resources for you to go to. Maybe some of you have bought into that prepaid legal services option that we all spend $9 per paycheck on now. I don't know what that would happen or whether they are any good at criminal defense lawyers. I hope so. That's what we're paying for. Get a lawyer. You might want to think about whether you would voluntarily consent to decrypt your device. You might have good reasons to do so. Maybe you can't afford to deal with all of the work and the hassle and the legal battles over decrypting your device. But just know that if you voluntarily consent to decrypt, you are giving up Fourth and Fifth Amendment claims that you might otherwise be able to raise. If you consent, those things go away. So just consider what those trade-offs are and what makes the most sense for your situation. If you do want to invoke your Fifth Amendment right against self-incrimination when you are demanded to decrypt your phone, you have to say so out loud. This right is not self-executing. You have to affirmatively invoke it and say that's what you're doing. Otherwise, you might unintentionally waive it by not saying so. Perversely, the Supreme Court has said that in order to invoke your right to remain silent, which is also part of the Fifth Amendment, you have to affirmatively say, I'm invoking my right to remain silent. And then you can go be silent. Anyway, you have to say it out loud. Be clear about it. And finally, if you raise a Fifth Amendment claim and the court rules against you and you still don't want to comply with that, you might get held in contempt. So you have to consider then, like, am I willing to go to jail for this and for how long? Because that's what contempt means. Anyway, on that cheerful note, that's what I got. Now, congratulations, you understand this really complicated and still evolving area of law. Here are some resources from some prominent civil liberties groups and the National Association of Criminal Defense Lawyers about compelled decryption. You can watch another talk that was given at a different conference last year. There's some resources about the border search situation that I talked to, that I said I wasn't going to talk about and haven't. And if you have any other questions, here's my email address. I'm at the Center for Internet and Society. We're on the 3rd floor above the law library over at the law school, and we're very friendly. So thank you.
Any questions for Riana?
Yes.
Hi. If no one else has questions, I'll ask this. I am a law student, and I may or may not be working on a brief related to this, so sorry if this is a little bit outside scope. So I'm having a lot of trouble understanding the contents of your mind framework. I found that the opinions are really opaque, and I don't really understand what the line is. Do you have any understanding on why is it that recalling a passcode would actually be using the contents of your mind? Why is that different from answering any question that cops would throw at you?
I mean, if you're answering other questions that the cops would throw at you, that's still the contents of your mind, and that's still testimony, right? So the Fifth Amendment right against self-incrimination means, if the cops give you that right to remain silent spiel, your Miranda rights, and then they ask you, did you do it? If you say, yeah, I totally killed that guy, that's testimony, and it's violating your rights if you've been advised of it or if you're compelled to talk. So you're right that there isn't really a line here. We're thinking about using the contents of your mind because then you're recalling and calling up, here's what my passcode is, and entering it in. And there has actually been some, you've probably read this, there's been some dissent among the courts in talking about well, should the order then say you just have to hand over the unlocked version versus you have to tell us what your passcode is versus you have to enter it while we're talking there. And I think that's a legitimate point of disagreement. You're not the only one who's confused. The courts get confused too. The fact that they've come out different ways is evidence of that. And so I think they really struggle with this. But overall, it isn't necessarily that different from asking you any other question, because when you respond to any other question, you're also using the contents of your mind when you testify in response.
So do you think that it's pretty clear that simple recall is using the contents of your mind?
Yeah, I mean, I would say, I think here's where the courts might draw the line between, just an involuntary, physical reflex versus, having to actually think to yourself, oh, what's the combination to my phone again? So I think simple recall, it is still the contents of your mind. And that goes, like I said, even to polygraph responses, where you're not necessarily, voluntarily controlling, what your physiological responses are, but what you're thinking, or your mental state is what's informing how you respond to that polygraph test. So, the way that you respond physiologically when you're asked what's your name is different than when you're asked, where were you on the night of the murder and did you do it, right? So that's kind of, I think, a good sort of borderline example of where something that is a physical characteristic of your body shades into being something that more involves mental processes. But it's a great question, and it's a difficult question. Other questions? All right, thank you everybody so much for coming.
Thank you.
Thank you.